Okay, let's unpack this. When we talk about modern statecraft, few instruments are as powerful or as profoundly complex as U.S. economic sanctions. They are essentially a precision economic weapon. They're designed to advance U.S. national security and foreign policy objectives, but for anyone navigating global business, from multinational corporations to legal professionals, they represent a massive, constantly shifting labyrinth of risk and rules.
That's absolutely right, and that's not an exaggeration. Sanctions are no longer some, niche legal specialty. They are a critical component of enterprise risk management for any company with a global footprint.
And for this deep dive, we are zeroing in specifically on the monumental legal framework targeting Russia.
We are. Our mission today is to cut through the density and give you the essential knowledge, the shortcut to being thoroughly well-informed, by unpacking the 4 core legal pillars that uphold this massive structure.
Okay, so what are those 4 pillars?
We're going to cover the general principles first. Then, primary sanctions, secondary sanctions, and finally, the specific tightrope walk for legal and compliance professionals. The goal here is real depth, but without the info overload.
Right, getting you up to speed quickly. So before we dive into the prohibitions themselves, it's crucial to understand who is in charge of writing these rules and, more importantly, policing them. Because in the U.S., this feels like a powerful multi-agency enforcement effort. It's not just one group.
It is a coordinated effort, absolutely, but one agency stands head and shoulders above the rest in terms of day-to-day enforcement, and that's the Office of Foreign Assets Control, or OFAC.
OFAC. Everyone in this field knows that name.
Yes, and for good reason. It's a crucial bureau within the U.S. Department of the Treasury's Office of Terrorism and Financial Intelligence. OFAC is the entity that maintains the critical sanctions lists, the Specially Designated Nationals List, the SDN List, and the Sectoral Sanctions Identifications List, or SSI List. And critically, they are the ones who issue the licenses and hand out the fines. They are, for all practical purposes, the ultimate arbiter of compliance.
So OFAC is the central command, but they have major operational partners. They're not working in a vacuum.
Precisely. The Department of State, for example, plays the critical role in foreign policy formulation and often initiates the designation process for entities or individuals. They're the ones setting the strategic direction, who to target and why.
And what about the Department of Commerce? I know they play a big role here, too.
They do, specifically as Bureau of Industry and Security, or BIS. This is a key distinction. While OFAC handles the financial side, the transactions and asset freezes, BIS controls the actual export, re-exportation, and transfer of goods, technology, and software. They administer the Export Administration Regulations, the EIR. So it's important to understand these restrictions often run parallel to, but are distinct from, OFAC's financial sanctions. You have to comply with both.
And this vast regulatory power, which reaches around the globe, it all rests on authority granted by Congress and the president, right?
Yeah.
This isn't just something the agencies decided to do on their own.
Correct. The legal backbone relies primarily on the International Emergency Economic Powers Act, or IEEPA. IEEPA, yes. It grants the president the very broad authority to declare a national emergency and issue executive orders to restrict economic activity. This is in response to unusual and extraordinary threats to U.S. national security. Most of the Russia sanctions stem from these IEEPA authorities, specifically a big one, Executive Order 14024, also known as the RuHSR.
And there's also specific legislation from Congress.
Yes, you also have specific legislation like the Countering America's Adversaries Through Sanctions Act, or CAATSA. CAATSA actually mandates sanctions programs against adversaries, and it codified many of the restrictions against Russia for various malign activities. Understanding these statutes reveals the just immense legal foundation underpinning the current compliance burden. It's not going away easily.
Okay, so that sets the stage. Let's get into the first pillar, the foundational principles. And let's start with the one that keeps global compliance officers up at night, the strict liability standard. This is the core danger zone because it essentially removes the defense of ignorance.
This is, and I can't stress this enough, perhaps the most crucial general principle for any global business to grasp. Sanctions violations are often designated as strict liability offenses.
Okay, so what does that mean in practice? What does strict liability actually look like?
What it means is that your intent is entirely irrelevant. If a prohibited transaction occurs, if funds move where they shouldn't, or a service is provided to a blocked party, that is a violation, full stop. Lack of due diligence, a simple clerical mistake, or, relying on outdated screening software does not excuse the violation.
So the classic defense of, I didn't know the entity was blocked, is simply not a successful legal defense against an OFAC enforcement action.
It absolutely is not. The law holds that your knowledge or your diligence, or more importantly, your lack of diligence, is irrelevant to the determination of whether a violation occurred.
So the act itself is the crime, regardless of intent.
Exactly. The practical implication is that mistakes, even completely unintentional ones, can lead to extremely severe civil and criminal penalties. We're talking about potential multi-million-dollar fines and, perhaps just as devastating, massive reputational damage that can freeze a company out of the global market. For this framework to function as a deterrent, compliance has to be considered essential for corporate survival.
Can you give us a quick, concrete example of how that intent becomes irrelevant, just to make it real for people?
Certainly. I mean, we've seen cases where financial institutions have been fined millions because their automated screening systems fail to catch a subtle transliteration error in a blocked person's name.
A typo.
A typo or a different spelling. Or because they relied on a third-party vendors list that hadn't been updated immediately following an OFAC designation. Maybe it was a few hours late. Transaction goes through, the violation occurs, and when OFAC investigates, they determine that the company committed the act, regardless of the good faith effort or the complete lack of malicious intent. It is the act itself that triggers the liability.
Wow. That harsh standard forces every company to conduct aggressive, proactive screening, which I think leads us immediately to the second massive pillar of general compliance, the 50% principle, or what's known as the aggregation rule.
Yes.
This is where ownership chains become absolutely critical, because an entity doesn't even have to be listed by OFAC to be considered blocked.
Exactly. This is a huge trap for the unwary. The 50% rule is an automatic, non-negotiable blocking mechanism. It's designed to prevent SDNs from simply hiding assets or transactions behind shell companies or complex subsidiary structures.
So how does it work? Precisely.
The rule is this. If an entity, let's call it subsidiary X, is owned 50% or more, either directly or indirectly, by one or more persons who are especially designated nationals, then subsidiary X is automatically considered blocked. It inherits the exact same prohibitions as the listed SDN itself.
And I really want to stress that point. It does not need to be formally listed by OFAC on the SDN list. It is blocked by operation of law.
Correct. And that's what makes compliance so challenging and, frankly, so expensive. You can't just do a keyword search on the SDN list and call it a day. You must perform deep, meticulous, beneficial ownership screening for every single counterparty you engage with.
I think the complexity here really sinks in when you look at how the aggregation works. What happens if a company, say a Russian joint venture, is owned 49% by one sanctioned individual and 49% by a different, totally unrelated sanctioned individual? Neither individual owns 50%, but the aggregate ownership by SDNs is 98%.
That is precisely the scenario the rule is designed to capture. The 50% rule applies to ownership by one or more SDNs, individually or in aggregate. So in your example, if two separate, unrelated SDNs each own 49%, even if the remaining 2% is owned by a non-sanctioned individual, the entity is owned 98% in aggregate by blocked persons.
And therefore?
Therefore, the subsidiary is automatically blocked, as if it were on the list itself. This necessitates mapping the entire beneficial ownership of all parties, analyzing tiered subsidiaries, complex joint ventures, and offshore projects to ensure that aggregate ownership doesn't cross that 50% threshold. It forces companies to look beyond the immediate counterparty and into the darkest corners of their ownership structures.
Okay, so a very high bar for due diligence. Finally, for this section, let's look at the scope. We can categorize the prohibitions into two main buckets: comprehensive and targeted.
Yes, and getting this clarity is essential for determining your compliance requirements. On one hand, you have comprehensive sanctions. These are effectively blanket regional embargoes that create no-go zones, prohibiting virtually all transactions by U.S. persons in or with these specific areas.
So for the Russia program, what are those no-go zones?
The primary examples are the prohibitions related to Crimea and the specific regions of Ukraine designated by executive orders, parts of the Donetsk People's Republic, or DNR, and the Luhansk People's Republic, LNR.
Meaning, those geographic zones are treated almost like a fully embargoed country like Cuba or North Korea from a transactional standpoint.
Exactly. U.S. persons face comprehensive restrictions on exports, imports, new investment, and virtually all trade and services in those specific territories.
And the other bucket?
Then you have targeted sanctions. These are list-based and highly specific. They don't block off a whole region. Instead, these focus either on specific individuals or entities, that's the SDN list, resulting in a full asset freeze, or they target specific activities or sectors. That's the SSI list. The distinction between a full embargo and a targeted restriction determines the scope of the underlying prohibition. It's the difference between don't do anything here and don't do this specific thing with this specific entity.
Okay, that makes sense. So with those foundational principles established, let's pivot to the second major pillar, primary sanctions.
Right, and these are the restrictions that are anchored directly in U.S. jurisdiction. So the immediate threshold question is always, are you a U.S. person?
And that definition, as we know, is extremely broad. It's designed to ensure that U.S. authority follows its citizens and companies wherever they operate globally.
That's the key takeaway. It's an expansive definition. Primary sanctions apply universally to U.S. persons. That means U.S. citizens and permanent residents, green card holders, wherever they are located globally, whether they're sitting in London, Hong Kong, or Moscow.
So your passport, not your location, is what matters.
Your passport or your residency status. It also includes any entities organized under U.S. law, like a Delaware corporation, including their foreign branches, and, importantly, anyone physically present within the U.S. at the time of the transaction, regardless of their nationality.
But the U.S. nexus doesn't end there, does it? Non-U.S. persons can still be dragged into the primary sanctions net if their transactions involve U.S. assets or the U.S. financial system, even if unintentionally.
That's a critical point for non-U.S. entities to understand. This is where the global reach really comes in. A non-U.S. person can face liability if they cause, aid, or abet a violation by a U.S. person.
And the most common way that happens is through the dollar.
Absolutely. The most common and dangerous example is the U.S. dollar clearing system. If a foreign entity, say a European supplier, processes a transaction for a sanctioned Russian entity using the U.S. dollar, that transaction has to clear through a U.S. correspondent bank. By submitting that payment instruction, the foreign entity causes the U.S. bank to execute a prohibited transaction, thereby creating primary sanctions liability for the foreign actor. They've pulled a U.S. person into their violation.
That single point, the global dependence on the dollar clearing system, is what gives the U.S. such powerful primary leverage over international actors. Let's now focus on the most restrictive tool in the primary sanctions toolkit, the SDN blocking mechanism, which mandates a total asset freeze.
The SDN list represents the maximal restriction. It is the economic equivalent of a death sentence for a company. If an entity or individual is designated as an SDN, any U.S. person who encounters them or their property must initiate a mandatory immediate asset freeze.
What does that mean to block property?
It means U.S. persons must block all property and interests in property of that SDN if that property is located in the U.S. or, and this is key, controlled by a U.S. person anywhere in the world. You have to freeze it, you can't return it, you can't deal in it, you just hold it.
And by property and interest in property, we mean the full spectrum tangible assets like real estate, but also cash, securities, and intangible business arrangements.
Everything. Absolutely everything. And importantly, the prohibition is twofold. It's not just about freezing the assets you find.
Okay.
Not only must the assets be frozen, but U.S. persons are subject to a total transaction ban. They are totally prohibited from providing or receiving any funds, goods, or services, directly or indirectly, to or from SDNs.
So no sales, no purchasing.
No debt servicing, no joint ventures, and virtually no professional services, outside of highly limited specific licenses, which are very hard to get. The explicit goal is complete financial isolation and, frankly, economic asphyxiation.
Moving from the total freeze of the SDN list, we encounter the more nuanced restrictions under Sectoral Sanctions Identifications, or SSI. This targets specific activities within key sectors, creating partial blocks rather than a total freeze of the entity. It's more of a scalpel than a sledgehammer.
That's a great way to put it. This is a sophisticated way to cripple the long-term financing of major Russian institutions without instantly collapsing global markets, which a total SDN designation of, say, a huge Russian bank might risk. SSI targets the structural pillars of the Russian economy: finance, energy, defense, and related material, categorized under what are called Directives 1 through 4.
And what's the core restriction here?
The core restriction here is not a total block, but a prohibition on dealing in new debt and new equity issued by these sanctioned entities, so you can't help them raise new money.
And the specific restrictions on debt maturity, the tenor, have become a fascinating window into how OFAC tightens the screws over time to increase economic pressure.
It's a fantastic illustrative detail of policy evolution in real time. It shows you how they can dial the pressure up or down. Let's look at the financial sector, which is covered by Directive 1. When these were first implemented back in 2014, the restriction applied only to new debt with maturity longer than 90 days.
Which meant they could still get short-term financing to operate.
Exactly. It was a serious restriction, but manageable. This tenor was later reduced to longer than 30 days. And now the restriction applies to new debt issued on or after November 28, 2017, with a maturity longer than just 14 days.
14 days. That is almost instantaneous. What does that policy shift do to the Russian financial institutions subject to Directive 1?
It severely limits their access to long-term capital from U.S. and affiliated global markets. 14 days is barely enough time for liquidity management, let alone funding large infrastructure or development projects. It forces those institutions to seek capital in non-USD denominated markets, often internal Russian markets, or markets in allied non-sanctioning countries. But even then, the lack of U.S. market access makes that capital much more expensive.
And you see a similar trend in other sectors.
We see a similar, though slightly less aggressive, tightening in the energy sector, which is under Directive 2. There, the debt tenor restriction moved from over 90 days to longer than 60 days maturity. This level of granularity mandates constant day-by-day compliance monitoring. You have to know the current tenor limit.
Beyond the SSI debt restrictions, we must also cover the broad, sweeping prohibitions put in place under Russian harmful foreign activities, sanctions, the RuHSR, or Executive Order 14-24. These truly expanded the scope beyond traditional debt and defense.
RuHSR significantly broadened the category of sanctionable activities. It moved into new sectors previously untouched. One critical area is the sovereign debt prohibition.
What does that entail?
Since June 2021, U.S. financial institutions are prohibited from participating in the primary market for ruble or non-ruble denominated bonds issued by key Russian financial authorities.
Like the central bank?
Exactly. The Central Bank of Russia, the National Wealth Fund, or the Ministry of Finance. You can't buy their new bonds.
And that ban later extended to the secondary market as well, effectively closing off almost all U.S. involvement in funding the Russian state.
Yes, that was a big step. Since March 2022, participation in the secondary market for those bonds is also prohibited for U.S. financial institutions. This is a direct attempt to isolate the Russian government from global capital, forcing them to rely almost entirely on their internal reserves or foreign partners willing to deal outside the U.S. financial sphere.
But the real shift in strategy, and what I think surprised a lot of people, came with the wide-ranging ban on specific critical services. This affects huge swaths of the global professional services industry, seemingly disconnecting Russia from the expertise that runs the modern global economy.
Absolutely. The RuHSR explicitly bans the exportation, re-exportation, sale, or supply of critical services to any person in the Russian Federation. This goes far beyond just military or high-tech exports. The list of prohibited services is expansive and targeted at infrastructure, governance, and technology. It includes things like accounting services, trust and corporate formation services, and management consulting.
Management consulting, that's a critical restriction because it touches strategic business decisions across nearly every industry. That's incredibly broad.
It is a profound restriction, and the list continues into high-value infrastructure and technology, quantum computing services and engineering, architecture, and construction services. This is a dramatic expansion designed to degrade Russia's long-term capacity to leverage high-end global expertise, maintain complex infrastructure, and access cutting-edge technology.
Let's nail down the practical impact of that service ban. If I am a U.S. person, a compliance consultant working remotely from California, and I am asked to advise a non-sanctioned Russian firm on, say, improving their HR management systems, is that a violation?
Yes, potentially. That's a fantastic question, and the answer is likely yes. Because the prohibition covers the supply of management consulting services to any person in the Russian Federation. The location of the U.S. person doesn't matter. The location of the service delivery, the recipient, does. OFAC views the exportation of the service as the problematic nexus. This means U.S. consulting firms, U.S. auditors, and U.S. engineering firms must have rigorous geographical and counterparty controls to ensure their staff are not supplying these listed professional services, regardless of the client's SDN status. This moves sanctions from simply blocking assets to a much more sophisticated, targeted form of economic degradation.
Okay, that covers primary sanctions. So now we move into the territory that causes the most international friction. We've established that primary sanctions target U.S. persons and activities connected to the U.S. financial system. But the true global reach of Washington's foreign policy tool comes through secondary sanctions.
That's right.
This is where we shift focus entirely, targeting non-U.S. persons even when there is no U.S. nexus whatsoever.
This is the critical jurisdictional shift, and you're right, it's the key concept that leads to global friction. If primary sanctions are the rules for U.S. actors, and I love this analogy, if they're the no-fly zone for U.S. aircraft,
Then secondary sanctions are the potent threat issued to everyone else globally. It's the international aircraft entering that zone, knowing that if they do, they risk being permanently banned from landing at U.S. airports.
perfect. It's a commercial ultimatum that forces the world to choose between Russia and the U.S. dollar system. That's precisely the mechanism. Secondary sanctions target non-U.S. persons who engage in certain activities relating to Russia, Iran, North Korea, or others, even if the transaction doesn't involve a U.S. person, a U.S. asset, or the U.S. financial system.
So just to be crystal clear, if a large Chinese financial institution deals with a sanctioned Russian entity, processes the transaction entirely in Chinese yuan, completely outside the U.S. system, they can still be penalized by the U.S. Treasury.
Absolutely. The U.S. response isn't about outlawing the transaction itself. It's about restricting the foreign actor's future access to the immense power of the U.S. market. The ultimatum is binary. You can securely do business with the sanctioned target, or R. You can securely do business with the U.S. financial system and the U.S. dollar, but you cannot confidently do both. Compliance means managing that existential choice.
This sounds incredibly powerful. But given the stakes, the threshold that triggers a secondary sanction designation must be precise. Yet the law relies on the, well, intentionally ambiguous concept of a significant transaction.
That phrase, significant transaction, is the ultimate compliance riddle, and you're right to call it intentionally ambiguous. OFAC consciously avoids providing a specific dollar amount or a simple quantitative rule. They understand that what matters is the impact and the strategic nature of the transaction, not just the size. The determination rests entirely on the totality of circumstances.
What key factors does OFAC scrutinize when evaluating that totality? Because this is where the sophistication of enforcement lies. What are they looking for?
They typically focus on 4 key areas, as suggested by their own official guidance. First is the scale and frequency.
Okay.
A single transaction may be significant if the dollar amount is huge, but more commonly, it's the repetitive nature and the pattern of smaller transactions that raise flags. A sustained business relationship signals intent and significance.
And second, the strategic value of the transaction itself.
Correct. The strategic impact. How close are the goods or services to the Russian military-industrial base or other sensitive sectors? Providing a few $1 million in generic consumer goods is viewed very differently than providing a few $100,000 in specialized components for defense systems. Proximity to the sanctioned regime's strategic interests dramatically increases the risk.
What about the actor's behavior? Does the perceived attempt to evade detection increase the likelihood of designation?
Significantly. That leads us to the third and fourth factors. Third is managerial culpability. Was senior management aware of the nature of the transaction? Does the activity reflect a pattern sanctioned by the institution's leadership, rather than an isolated error by a junior employee? An institutional failure is far riskier.
And the final one?
And finally, deceptive conduct. Any attempt to obscure the actual parties involved, such as structuring payments through layers of shell companies, falsifying end-user certificates, or deliberately stripping key information from wire transfers, significantly increases the likelihood of secondary sanctions designation. Evasion demonstrates malicious intent to circumvent U.S. law, which is itself a huge red flag.
So if a foreign financial institution is determined to have engaged in a significant transaction for a sanctioned Russian entity, what is the ultimate penalty? What happens to them?
The immediate and often devastating penalty is the potential loss of access to the U.S. marketplace and financial system. This is often enacted through what are called correspondent account or payable through account, co-account prohibition. Yes. Under RuHSR Directive 2, for instance, the U.S. Treasury can prohibit U.S. financial institutions from opening or maintaining a captor on behalf of the designated foreign financial institution.
For our listeners who might not be deep in finance, why is losing a correspondent account a death sentence for a global bank?
It's catastrophic. It truly is, because the captor is the mechanism by which a foreign bank accesses the U.S. dollar clearing system. It's their pipe into the dollar world. Without a correspondent account at a U.S. bank, they cannot process international transactions denominated in U.S. dollars for themselves or for their clients.
So it cuts them off completely.
Completely. Since a massive portion of global trade is settled in dollars, losing CAATSA access essentially freezes that foreign institution out of global finance. It eliminates their ability to facilitate cross-border transactions for their clients, and it cripples their liquidity. It is the most powerful deterrent short of a total SDN designation.
And the ultimate risk, of course, is that full SDN designation, which can be imposed on any person who provides material support to others who are blocked.
Yes, and that risk extends across the globe. We've seen in recent years the U.S. designate non-U.S. entities based in jurisdictions like Singapore, Turkey, or the UAE for providing material, financial, or technological support to designated Russian persons or military activities. Secondary sanctions are the tool that makes the U.S. financial footprint truly global.
Okay, so that brings us to our fourth section. If the regulations are complex for global businesses, they are doubly complicated for the U.S. legal and compliance professionals, the U.S. persons who advise those businesses. Their role requires walking a very specific tightrope to ensure their advice doesn't cross the line into a prohibited service or, more dangerously, prohibited facilitation.
It's especially tricky because providing any service to an SDN is generally prohibited, yet due process and the rule of law must be maintained. So OFAC explicitly authorizes certain activities for U.S. lawyers and compliance officers, providing critical safe harbors for the legal profession.
Okay, let's be very clear here. What are those permitted, authorized services?
A U.S. person is explicitly authorized to provide legal advice on U.S. sanctions compliance and the requirements of the laws of any U.S. jurisdiction.
So a U.S. lawyer can tell a sanctioned Russian company what U.S. law says?
Yes. A U.S. lawyer can advise a Russian client, even a sanctioned one, on how to comply with OFAC regulations or how to petition for the removal of sanctions. That's considered legal counsel. They are also permitted to provide legal representation in U.S. domestic court, arbitration, or administrative proceedings.
So if a sanctioned Russian company is sued in a New York court, a U.S. lawyer can represent them in that specific litigation, even though direct business transactions with that company are blocked.
Precisely. They can also represent sanctioned parties before U.S. agencies regarding the imposition or enforcement of sanctions, meaning they can advise them on how to respond to an OFAC subpoena or a licensing request.
What about things like intellectual property?
That's another specific carve-out. Transactions incident to the filing, prosecution, or maintenance of intellectual property protection like patents, trademarks, or copyrights in the U.S. or Russia are specifically authorized by General License 31. This shows a policy balance. The U.S. wants to maintain the integrity of its own legal system and respect IP rights, even for sanctioned parties.
That balance is crucial. But this permission comes with a very large, dangerous red line. The broad prohibition on facilitation. This, you're saying, is the single biggest risk factor for any U.S. person in a global compliance role.
It absolutely is. Facilitation is broadly construed, and it must be understood in its maximum scope. It means U.S. persons cannot facilitate what they are prohibited from doing directly. OFAC construes facilitation very broadly to mean assisting, supporting, or conspiring with a non-U.S. person in transactions that directly or indirectly involve sanctioned parties. The intent is to prevent U.S. persons from being the architects of sanctions evasion, even if they don't touch the money themselves.
Give us some practical examples. What activities are U.S. compliance professionals or executives most likely to fall into that are clear violations of the facilitation ban?
The examples are highly specific, and they focus on the transfer of knowledge or opportunity. First, referrals of sanctioned business opportunities to non-U.S. entities or individuals.
So if a U.S. executive at a multinational firm gets an inquiry from a sanctioned Russian entity they can't handle,
yes.
They can't simply pass that client off to a non-U.S. affiliate in Europe or Asia and say, you handle it.
That's exactly right. That referral is facilitation. The U.S. person used their position to direct business to the sanctioned party, even through an intermediary.
So the U.S. executive must act as a firewall, not a conduit.
Absolutely. Second, approving or reviewing deal documents for non-U.S. affiliates, or engaging in negotiations on their behalf related to a sanctioned transaction. A U.S. person should not be giving the green light or providing strategic direction for a non-U.S. subsidiary to enter into a transaction that the U.S. parent company couldn't do itself. If the U.S. executive's fingerprints are on the prohibited deal, it is facilitation.
This sounds like U.S. personnel must be entirely, and I mean entirely, firewalled from operational decisions related to sanctioned parties, even if those decisions are technically executed by a foreign subsidiary that might not be bound by primary U.S. sanctions.
That's the compliance reality. It requires strict internal controls. The third and perhaps most insidious example is altering internal policies to transfer decision-making authority to non-U.S. persons, specifically to bypass U.S. prohibitions.
Give me an example of that.
Okay. Say a U.S. executive normally has authority over any transaction over $10 million. A prohibited deal with $12 million comes along. If they suddenly amend the corporate charter to give a non-U.S. executive in another country authority over deals up to $15 million, just so that executive can approve this one specific deal. That deliberate policy change intended to circumvent sanctions is facilitation and a direct violation. OFAC sees right through that.
And even when legal services are authorized, the payment for those services remains complicated because the funds themselves belong to a blocked person.
That's right. This is a practical nightmare for law firms. The receipt of payment from SDNs for authorized legal services typically requires a specific license from OFAC. This is because the payment itself involves the transfer of property or interest in property of a blocked person, which is prohibited without explicit authorization. The lawyer may have permission to provide the service, but not necessarily permission to receive the funds.
So to summarize this complex section, what essential proactive risk mitigation steps must a company take to navigate the U.S. sanctions landscape?
Compliance needs to be proactive and, frankly, obsessively granular. First, as we discussed, granular ownership screening is mandatory. You have to correctly apply the 50% rule and identify beneficial owners and indirect control, moving beyond surface-level list checking.
Okay, what else?
Second, companies must constantly map indirect supply chain exposure and geographic risk, paying special attention to commodities or services originating from or transiting through embargoed regions like Crimea, DNR, and LNR. And third, due to the rapid pace of designation and the frequency of general licenses, meticulous license management and perpetual monitoring of OFAC list changes are essential. You have to ensure that U.S. persons do not, in any capacity, act as conduits to bypass U.S. prohibitions.
That brings us to our fifth section then. While the prohibitions we've discussed sound rigid and comprehensive, the U.S. government needs flexibility to manage foreign policy, support humanitarian concerns, and allow for the practical realities of global commerce. This flexibility is found in general licenses, or GLs, and this is where the compliance difficulty spikes dramatically. It's a labyrinth of exceptions.
It really is a labyrinth. General licenses show the practical complexity of compliance in action. OFAC issues dozens of these for the Russia program alone. The critical challenge for global compliance teams is that they are numerous, highly specific, constantly updated with amendments, and they often carry expiration dates. Compliance requires not just knowing the rule, but knowing the precise, often short-lived exception and satisfying all its narrow conditions.
Our earlier material was a bit brief here, so let's really highlight the operational headache of these GLs. Let's review a few examples from the RuHSR general licenses to illustrate that detail and scope, starting with humanitarian exceptions.
A prime example is GL6C. This authorizes transactions related to fundamental humanitarian needs. It permits dealings involving the production, manufacturing, sale, or transport of agricultural commodities, medicine, and medical devices. This ensures that the U.S. government is not seen as blocking essential life-saving commerce, even with sanctioned entities. Importantly, GL6C also covers related medical research, including clinical trials and specific transactions related to COVID-19.
That specific detail, including COVID-19 research, shows how highly customized these exemptions are. They're not broad strokes. We also see licenses designed to allow U.S. citizens to maintain a normal life, even while residing in Russia.
Yes. For U.S. persons who physically reside in the Russian Federation, there's GL19. This is a mechanism for personal maintenance. It authorizes transactions ordinarily incident and necessary for their daily living, including payment of housing expenses, acquiring goods or services for personal use, payment of taxes, fees, or even the purchase of public utility services.
Which is vital because
without it, basic acts of living like paying rent to a Russian landlord or paying your electricity bill could be viewed as a prohibited transaction. It's a practical necessity.
And the nonprofit sector must also rely on these highly specific authorizations for their work.
They absolutely do. They rely on licenses like GL27. This authorizes certain activities by non-governmental organizations, or NGOs, related to specific projects. Things like humanitarian aid, democracy building, education, environmental protection, or similar projects benefiting the people of Ukraine or Russia.
But there must be a catch.
There is, and it's a big one. This authorization is explicitly conditioned on the only involvement of blocked persons being the processing of funds by blocked financial institutions. They cannot be the end beneficiaries, the decision makers, or the primary recipients of the services.
That is a very fine line to walk, even for charitable work. You need to verify that the blocked entity is only acting as a pass-through bank, not deriving any strategic benefit.
Precisely. And the licenses often protect massive structural systems like global commerce and aviation safety. Think of GL40C. This authorizes transactions necessary to ensure the safety of civil aviation, but notice the narrow scope. It's only for non-Russian registered aircraft. It covers the provision of goods, technology, or services for use on aircraft operated solely for civil aviation purposes. It's a safety valve for global movement, not a blanket permission slip for Russian carriers.
Finally, we frequently see these general licenses used specifically for winding down transactions when a major entity is newly designated.
That is a crucial feature of mitigating the systemic shock of an SDN designation. When OFAC designates a large company or financial institution, they recognize that U.S. persons need a limited amount of time to divest assets and conclude existing contracts without triggering immediate violations.
So it's a grace period.
Exactly. These wind-down licenses, such as those issued for Expo Bank Joint Stock Company or other recently designated entities like GL79 or GL85, are temporary authorizations. They typically grant U.S. persons a grace period, often between 30 and 90 days, to transfer assets, terminate contracts, or close accounts, and avoid an immediate violation.
The massive takeaway from this entire section on general licenses is that compliance is far from a static list check.
It is entirely dynamic. The sheer volume and specificity of these exceptions, their narrow conditions, and their often short expiration dates underscore that compliance is a constant, detail-oriented task. It requires perpetual monitoring of amendments and renewals. Any global company must maintain meticulous records proving not just why they complied with the underlying prohibitions, but how they complied with the current license regime at the exact moment of the transaction.
Okay, that was a very comprehensive deep dive.
We have completed a comprehensive examination of the U.S. sanctions framework targeting Russia. To quickly recap the 4 core pillars, the foundation rests on the principle of strict liability. Mistakes are costly and your intent is irrelevant. We then established the critical difference between primary sanctions, which target U.S. persons, and U.S. NEXUS activities. That's the total asset freeze under SDN, the debt restrictions under SSI, and the expanded service bans under RuHSR.
We then explored the global reach of secondary sanctions, which extend U.S. jurisdiction extraterritorially via the powerful Commercial Ultimatum, targeting non-U.S. persons for providing significant transactions or material support. And finally, we detail the tightrope compliance professionals walk, ensuring they provide necessary legal advice without crossing the line into prohibited facilitation, which is defined as assisting a non-U.S. person in avoiding the U.S. prohibitions.
It is a vast, complex, and as you said at the start, an immensely powerful system designed to enforce U.S. foreign policy objectives globally.
And that power leads directly to our final provocative thought. The source material highlights just how dominant U.S. sanctions are globally. The U.S. imposes roughly 3 times as many sanctions as any other country or international body, and its financial restrictions touch 1/3 of all nations.
It's an incredible figure.
And this dominance is enforced almost entirely by the U.S. dollar's role as the global reserve currency. The dollar's hegemony is the engine of the sanctions regime.
The ability of the U.S. to enforce that commercial ultimatum rests entirely on the world's need to transact in U.S. dollars. If you don't need the dollar, the threat is empty.
But the very complexity, and crucially the aggressive extraterritorial reach, those secondary sanctions we discussed, create substantial friction. And not just with adversaries, but with key allies like the EU, who sometimes view it as an unacceptable interference in their economic sovereignty. More critically, the consistent use of this power spurs proactive countermeasures.
We are already seeing attempts to mitigate this sanctions risk through global de-dollarization efforts, the development of non-dollarized financial infrastructure.
Right, things like the Russian-developed system for transfers of financial messages, SPFS.
Or the China-supported cross-border interbank payment system, CIPS. Or even just attempts by other nations to use bilateral currency swaps for trade. These mechanisms are all direct responses to avoid the commercial ultimatum and its associated risks.
So here's the critical question for you, the listener, to mull over. Given the immense global economic power that enforces these rules, how long can the U.S. government continue its strategy of aggressive extraterritorial enforcement through secondary sanctions without inadvertently accelerating global efforts to adopt alternative, non-dollarized economic systems, and in doing so, diminishing the very financial power that makes the sanctions effective in the first place? That is the ultimate ripple effect of the commercial ultimatum.